Okay, there's Jody. Wonderful. Okay, good morning, everyone. Thank you for joining us on this live webinar. Today's discussions will be on lease agreements. With me, as usual, is Jody Blount, an attorney for Schneider, Galloon, Reef, and co-attorneys. They're in Cape Town. I'm on the 7th floor. They're on the 18th floor, if I believe so. So we're in the same building, but on different floors. We're keeping it COVID-19 compliant. Jody, how's things your side?
Fantastic. Hey, enjoying this lovely summer weather here in Cape Town. And Advocate Abduroaf, thank you so much for having me on your show.
No, wonderful. Always happy to thank you to you. Also, always happy to depart knowledge to people, and people can make use of it. Especially things like lease agreements, where many people in South Africa, they enter into lease agreements. Not many people own homes, or some people they own a home, but they leasing the property out to a third party. So it's a very relevant topic. Jody, maybe you can start with us generally. Maybe start with the residential properties and deal with some commercial properties. But what are the issues a person must look into before you or when you enter into a lease agreement?
So yeah, from the onset, it's obviously with the property boom that happened in Cape Town a couple of years ago, and obviously just slowly lulling out now. Rentals have been a massive bone of contention, especially with the PI Act evictions and all of that tie into it. So it's a ever recurring bit of law. And I think the major aspects that people do come to me with the questions on a daily are the aspects of the deposit, what the landlord's duties are in terms of the deposit. And secondly, the incoming and outgoing inspections, because those place quite a lot of duties on both the tenants, but more so the landlords, and the duties that they need to do ahead of entering into the lease agreement, as well as at the conclusion. Failure to comply with the Rental Housing Act opens the landlord up to quite a lot of risk at that aspect at that time. So yeah, from the rentals perspective and the lease agreements perspective, those are the major two questions we've been having, and perhaps we could touch on those aspects a little bit more in depth today.
No, wonderful. So I can imagine the inspection part. Firstly, you get onto the premises. You will have to go with the landlord and check if everything's in order. Does the geyser work? Does the is there any leaks, etc.? So how does it generally work? Is it a piece of document you look at, you work with, do you sign something?
So that's exactly where it comes, where the confusion comes in. That many people, especially the landlords, will think that, look, going around the property with the tenant, the day that the tenant takes occupation of the property, and taking a couple of pictures will suffice. Unfortunately, if you are left at the end of the lease as a landlord with a difficult tenant who's now damaged your property, you're going to be into the difficult situation of the court coming back to you and saying, look, we know that you thought you did an ingoing inspection, but unfortunately that's not suffice. And the reason they've been advocate is because the incoming and outgoing inspections are dealt with specifically in terms of legislation being the Rental Housing Act. And in terms of the Rental Housing Act, incoming inspection, it needs to be done technically in terms of the act before occupation is done. So that is obviously before the lease is signed as well. Further to this, the act goes so far as to say that the parties, if they do notice any defects in the property, actually need to pin these down in writing, and both parties need to agree to same. So thereby, at the end of the day, what you do want for a proper incoming inspection is a list of defects annexed to the back of the lease agreement, signed by both parties. Obviously, signing the actual lease agreement to which that is attached will be sufficient, but that is the bare minimum at starting. The photographs that the landlord and the tenant could take at the start are just further supports of that ingoing signed document.
And I can imagine also they can be those photographs can be disputed afterwards as well, because someone might say you took this photographs later or you took it earlier. So unless it's appended to the specific lease agreement and initialed by the parties, there can be a lot of room for abuse taking place in the future. So you want to avoid that from happening.
You're opening up another kettle of fish with the law of evidence in that one, but we won't even go down that route, eh?
No, wonderful. But Jody, thank you very much. It's very useful to know. I did not know that the inspection that has to take place before you move into the premises and the inspection that happens afterwards. So to speak to us smaller bit about the inspection that happens afterwards. What if the photograph of the walls were nice and clean and everything? At the end of the lease agreement, the walls are dirty, the geysers broken. What happens then?
So obviously, if you do have a signed incoming inspection, this is where we'll go a little bit further with the damages to your property. Unfortunately, if you haven't done the incoming inspection, we can tell you that, look, you are at a loss now, we unfortunately can't proceed further from here. But if you've spoken to an attorney, you've done the good steps, you've done your income and inspection, then you have the necessary authority to actually put those damages to the tenant. So the process there again is quite clear in terms of the Rental Housing Act. And in terms of the Act, 3 days prior to the tenant leaving the property, the tenant and the landlord are supposed to come to an agreement on a mutually beneficial time or a mutually agreeable time that the parties can jointly inspect the property, and thereafter they can note all the damages that have taken place during the period of occupancy. Obviously, the damages that we are looking for are not the general wear and tear things. They're out of the ordinary things that one wouldn't expect from the ordinary course of ownership. So it's but then again, I think let's not put forth a finite list, because the list is quite difficult and one would need to read into it a little bit with some experience. But obviously, the things such as general wear and tear cannot be deducted from the deposit. It's only for actual damages that the tenants have caused, or if the wear and tear is possibly through negligence or other aspects like that, then they would be able to deduct those damages. So at the end of the day, being the end of the lease, when the parties do want to now part ways, the ideal situation is that 3 days prior to the lease ending, the parties meet together at the property, note all these damages, and then agree that, look, this is what actually needs to be repaired in the building. Failing same, if there are actually no repairs noted by the landlord and the tenant, then the landlord's actually required to refund the deposit within a period of 7 days from that inspection. Should the landlord then, or in the alternative, should there actually be damages that were need to be repaired, the landlord's then only required to refund that deposit amounts less the amount spent on the damages, and that would only be after a period of 14 days. And obviously, you as a tenant, you have more than within your rights to request every invoice that was utilized or deducted from said deposit. The other occurrence that occurs most of the time is when, say, you've had a possible breakdown in relationships, or say parties are maybe possibly too busy at the conclusion of the lease agreement, that the landlord will attend at the income and inspection, but the tenant will by that time have already vacated the property, he's already kind of moved on with his life, moved on with the property, and doesn't attend at the outgoing inspection. I would warn tenants against doing something like that, especially refusing an invite from your landlord, because obviously the authority then lies with the inspection conducted by the landlord, and he can, within reason obviously, put forth the damages without contestation at the end of the day. And if there are damages at that stage and you fail to attend the outgoing inspection as a tenant, the landlord's then only required to refund the deposit a period of 21 days later. So you can see that the period jumps from 7 to 14 to 21 days. So as a tenant and as a landlord, it's always in the best interest to attend at that inspection within the 3 days before exiting the lease, rather than wait until the landlord actually invites you to do same.
Now, so Jody, what if there is a dispute? What if the landlord says something and the tenant says something else, and there's a dispute regarding whether or not it was a reasonable wear and tear or not? What happens then?
Then, advocate, that is a very interesting question, because I would think then it is the time that you get an expert involved, because obviously one person's opinion as to what is reasonable wear and tear versus what is negligent damage often differentiates. And I think getting an attorney involved at that stage is very important. Attorney can direct you as to the authorities to rely on, as to who we could possibly petition. We could get building experts involved, X, Y, and Z. But obviously, even just a independent attorney or mediator having looked at the matter can give you a eyeball guess. And if you, obviously, I'm not a guess, more of a eyeball understanding based on case law that has happened. And obviously, he can give you an opinion as to which way it's going to go, and the parties therefrom can decide, do they want to continue with the dispute in this vein, or do they rather want to settle and move forward with their lives? At the end of the day, they don't want to go to court. Also, there is also the rental housing tribunal available to them, which is another option.
No, Jody, thank you very much for that. I think we just made it to 9 minutes here, and our cutoff time is 10 minutes. Jody, thank you for your time. Appreciate it. Next week again, we'll do another 10 minutes and another legal topic. To the viewers, thank you very much for joining us, and please share this video. Jody, any final points on your side? Any final comments?
No, just thank you for your time. And as you say, we love chatting law. So if you guys have any questions at home, please do hit us up. We're always glad to assist.
Awesome. Thank you, Jody. Chat to you soon. Take care. Thank you. Bye-bye.
Thank you. All the best.
Bye bye.
Cheers.